My dad walked me home and he said, I could never be more proud of you than I am today because you stood up for a wrong. And he looked at me and he said, in life, you may never get a second chance to stand up for a wrong. And I was sobbing and I said to my dad, why didn't you defend me to the principal? And he said, because you're never too young to learn to stand on your own.
This is RVA Trial Lawyers, Virginia's trial lawyer podcast, hosted by Sharif Gray and Niall Abuzaki.
All right, we're back, RVA Trial Lawyers, and today we are fortunate enough to have Judge Mark Bennett. Judge Bennett has served as a federal district judge in Iowa for many, many years, and he wrote an article a number of years ago called The 8 Traits of Great Trial Lawyers, or something along those lines. And it's been an article that I've certainly referred to many times and shared with probably too many people. But it's really a privilege to have you here, Judge Bennett. Welcome. If you wouldn't mind, please introduce yourself to our listeners.
Sure. I'm Mark Bennett. I retired 6 years ago as a United States District Court judge after 24 years. I was a pretty good case manager, so I got invited to judge in other districts. So I've been in the district of, the Middle District of Florida, the Northern and Southern districts of Iowa, the districts of South Dakota, North Dakota, Idaho, Arizona. I sat a lot in the district of the Northern Mariana Islands and Saipan, the farthest reaches of the federal courts. I spent about 3 years commuting back and forth between Sioux City, Iowa, and Saipan after their judge retired there. And I tried all their civil and criminal cases. And then when I was back in Sioux City, it worked out great because at 5 o'clock Iowa time was the beginning of the next day, 8 o'clock in the morning in Saipan. So I would then handle their hearings and sentencings. I did remotely on video conferencing. And so I sat a lot on the Ninth Circuit Court of Appeals. My last 5 years as a district court judge, I had about a 10% Ninth Circuit caseload. So I've had the experience of being a trial lawyer, a United States magistrate judge, a district court judge with pretty far-reaching experience in a number of districts, and then sitting on, I sat a little bit on the Eighth Circuit, but I mostly sat on the Ninth Circuit. So I had a lot of great experiences. I taught trial advocacy to law students, and so I had a lot of great opportunities in life and tried to make the most of them.
Judge, again, we're super excited that you're with us. I think it's very clear that you know what works and what doesn't work when it comes to being a trial lawyer in a courtroom. Is that fair to say, based on what you've seen?
Yeah, and I think one of the reasons I know that is not my own idiosyncratic views of what I think works and doesn't work. But from day one as a trial judge, I created a jury questionnaire, and I did it for a couple of reasons. I did it to empower the jurors. So during jury selection, I would explain to them that at the end of the trial, after they've reached a verdict, I would give them a jury questionnaire to fill out, and they would evaluate the trial lawyers both on objective and subjective criteria. They would evaluate me as a trial judge. They would evaluate the jury instructions. And I would change up what I wanted to evaluate. For a period of time, I wasn't satisfied with the lunch we served the jurors on their last day of deliberation. So I had them evaluate the food that they got, the snacks that we had for them in the jury deliberation room. I changed the quality of the chairs in the jury box because I found out the jurors didn't think they were very comfortable. And so I relied heavily on juror feedback. And then what I decided to do was, when those juror questionnaires came back, my secretary would copy them off, and we would just provide each lawyer what the jurors thought about them. We wouldn't do their opposing counsel. I didn't think that was fair because the way lawyers advertise now, they probably use that against other lawyers that they compete for business. So I was happy to share with them the juror evaluations of the lawyers. And so, but, for the most part, the juror evaluations actually matched my evaluations of the lawyers.
Is there something like an overarching theme that you saw when it came to an effective trial lawyer in your courtroom?
Yeah, I would say the overarching thing would be, if I would have to say, they're great listeners. Most lawyers are great talkers. They're not very good listeners. They don't listen to the answer of the witness. They have a script, so they're going to ask the next question, regardless of how the witness answers the prior question. And so I think all great trial lawyers are great listeners. They're great storytellers, and they're super well prepared. So I would say those three attributes, and it's hard to leave things out, but I think I've never met a great trial lawyer who wasn't a great cross-examiner. I've seen some really good cross-examiners who weren't really very good at anything else, so I wouldn't consider them great trial lawyers. But I think every great trial lawyer, they're great listeners, they're well prepared, they're gritty, they're great cross-examiners, and above all, they're great storytellers.
What judge led you to have this interest in trial work and to get you to the point where like you've now published numerous things that frankly could serve as a guide to a young lawyer trying to become a trial lawyer? What was that spark for you?
Well, I had a lot of great mentors, and I started my own law firm when I graduated from law school. I hung out a shingle. The very first case I filed, I argued in the U.S. Supreme Court 3.5 years later. I had 3 more cert petitions granted by the U.S. Supreme Court before I was 32. And so I was really good at spotting legal issues, but I had really great mentors, other lawyers. And so one of the things I learned is just kind of common sense. I got to befriend the people who worked in the clerk's office in federal court. So if I was about to file a case, I would go into the clerk's office, talk to Nancy or Helen or Sarah and say, I'm about to file this case. Can you think of a case that was similar? Oh, yeah. And they'd find a case. Who are the lawyers? They'd give me a copy of the pleadings. I'd call the lawyers up and say, hey, I'm a young whippersnapper. You're an experienced lawyer. Can I come over and talk to you? And I never once had a lawyer turn me down about being willing to talk to me about the case that they had, mistakes that they made, how I can improve. And so I had this great series of incredible mentors. And so I felt an obligation to give back to the profession because so much was given to me by so many great lawyers who were incredibly willing of their time. So that was a big inspiration to me. And I would call lawyers out of the blue. I remember one time I called, I'm drawing a blank, it was Belli, great San Francisco trial lawyer. I called him out of the blue, and the secretary put me through to him without even asking what it was. And I immediately went to my secretary after I talked to Marvin Belli. I had a couple questions about damages. I said to my secretary, stop screening my calls. Belli could take a call from some podunk lawyer in Des Moines, Iowa. I could certainly take calls with people. So I just learned from, a whole series of different great lawyers who taught me so many things about the practice, not just about being a good trial lawyer, but about the practice of law.
Something that I've noticed, and I've heard said from some senior trial lawyers, is that some of the best trial lawyers out there typically are also some of the nicest and just kindest people. Oftentimes I think it's easy for us to think, oh, the badass trial lawyer is the guy with the arms crossed and the mean look, and I'm going to hammer you, all that. But really, when it comes to effectiveness, those who are effective in the courtroom, you just find them to be just wildly kind and considerate and willing to help. And I've certainly benefited that from myself in the plaintiff's bar. The amount of people that I've gotten to speak to who are willing to assist and share I've lost count. It's really been amazing.
Sharif, that is so true. Most of the best trial lawyers I've known are just really nice people. They are just really nice people. And I primarily did plaintiff's work, but the last half of my practice, I was pretty much 50 on defense side. And whether they were plaintiff's lawyers or defense lawyers that I was up against, the vast majority, there were very few bad apples. I became good friends with. Matter of fact, I got great support when my name was floated to be a federal judge from the lawyers that I was opposite in cases because they were nice to me. And with a couple minor exceptions, I was really nice to the lawyers opposite me. So I think that's important. You can be really good at your craft and be really nice.
And Judge, that's where I'm going to jump in and ask a question. So I want to focus a bit about you as a trial lawyer, and then I want to focus a bit about your transition as a judge. So let's talk a bit about that craft as a trial lawyer. You had those mentors. What did you learn from those mentors as a trial lawyer that you then either affirmed or built on as a judge?
A great question. I've never actually thought about it that way, Niall, but it's a great question. Well, one is hard work and preparation. And so I think that was my forte. I often was up against major national law firms on the other side of my cases, and I would use my small town country bumpkin to my advantage because I would lure them into a false sense of security. Um, and So I was never intimidated by, I didn't care if the other side had 7 Harvard and Yale and Columbia and NYU lawyers on the case and was just little old me. I knew I could outwork them. I would never let them know that, but I knew I could outwork them. And so hard work, it gets you, I think, everywhere in life. And the thing about practicing law, if you think about it, to me, it's like a pyramid. It's overcrowded at the bottom. It's pretty crowded in the middle. There's plenty of room at the top. But most people, for some really good reasons, maybe work-life balance, they're just not willing to put in the time and effort to make it to the top. I'm not critical of people like that. But if you want to make it to the top, I think you have to work really, really, really hard and have a burning desire, not to be better than anybody else, but be the best trial lawyer, or the best trial judge, or the best accountant, or the best archivist, or the best street sweeper, whatever your calling is, to try and be the best that you can be. And not everybody has that drive.
Did Judge Bennett miss the Mr. Bennett trial lawyer when he became a judge?
Early on, I did, but I recognized that to be a better trial judge, I had to shed that, I had to stop thinking like a trial lawyer, although I never totally stopped. So I was the first federal judge in the country to have email, actually. And so I had instant messaging. So whatever my new law clerk was for the year, they would be in the courtroom with me, and I would instant message them all day long during a trial or a hearing. What do you think she's going to do next? How do you think she's going to handle this situation? And I would send emails and they would respond. And then on the break, I would meet with my law clerk and say, well, how do you think she did? What could she have done better? So I never stopped having that sense of wanting to be better. And I offered to every lawyer that appeared in front of me, I said, I take very good notes. And at the end of the trial, once we've got a jury verdict and post-trial motions are over, if you want to come into chambers and meet with me, I'll give you my personal critique of how you did, what you did well, and what you could work on better. So I never stopped kind of teaching trial advocacy because we're all lifelong learners, right? We want to get better at our craft, no matter what our craft is. And feedback is a really great way to get better.
Did many exercise that offer?
Very few.
Very few.
Very few. Never understood why, but, I think fear. They don't want to hear the negative stuff, but the negative stuff is what helps you improve.
Judge, I will tell you, as a young attorney, if you ask me which judges had the most influence on my career, it's those judges that either I went and knocked on their door and gave me feedback on how to improve. And it's those same judges, because after I knocked on their door, they would come and walk down the hallway and knock on my door and just sit there and just chat about life.
Yes.
And they're the ones that gave me the comfort and the standing in court to just continue to build on my craft. And I owe it to them. They're three judges out of Montgomery County, and I owe it to them because they helped me build my craft by making me comfortable in the courtroom.
Right. Yeah, that's so true. That is so true.
Yeah, and I guess also the realization that judges are people too. I mean, now and I talk about, well, some of them, right? No, I'm joking. But now
no, it's not a joke. You're right. Only some of us.
Yeah, only some of you all, right? Yeah, now and I talk all the time. It's like, oh, you got a bench trial, treat it like a jury trial. I mean, do an opening statement. Like,
yes.
Don't forget that the judge needs to hear a story as well, right? Like it's
exactly.
Oftentimes, I mean, law school very much teaches that the law, in some respects, black and white's probably the wrong description, but operates based solely on the rules of evidence, the facts presented, and really kind of discounts just the persuasion piece and the connection piece and the storytelling piece. But what we've learned over the last, I've been practicing almost 11 years now, it's a couple years longer than myself. I think we've learned that sometimes the story is far more powerful and far more persuasive than any independent piece of evidence or rule or anything like that. So,
absolutely.
Please.
Yes, the story is so important. I had one particular assistant U.S. attorney, whenever I found out he was going to be in the trial with me, it just made me ill, because his opening statement would be, well, I'm going to call witness A, and here's what they're going to tell you. And I'm going to call witness B. Here's what they're going to tell you. And just summarized it. Didn't tell a story at all. And you could see after 5-6 minutes, the jurors had a glazed look in their eye, because it wasn't storytelling. It was just summarizing what a witness would say with no context to it.
Judge, I'll tell you, you hit the nail on the head. Fortunately for me, I also have the opportunity to teach trial ed, and I tell my students that if I hear the evidence will show, I'm deducting points.
Yes.
Yeah, there is no evidence will show. You better start with a very compelling story. It's all about recency and primacy. I want you to start strong and strong. I want to hear your theme 3 times within at least your opening. And it has to be active, present sense, and walk them through as they are actors within your story. Walk them through and take them to the scene. Let them see what the witnesses saw. And that's so moving. And, and we're going to get to your, 8 traits for a great trial attorney. We're going to get them listed out. But and I saw that in there, like the active language and just.
Well, but your point about having a theme and hearing it is so important. So I must have been like 6 months out of law school, maybe a little longer. I went up to Minneapolis and I heard Jerry Spence. I don't remember who the other speakers were, but I knew about Jerry Spence, talk about themes. And so not too long after that, I was trying an age discrimination case against AT&T. You guys are too young to remember this, but their theme was reach out and touch somebody. That was their theme. So my theme in my age discrimination case was reach out and crush somebody. It was really corny, one of the worst themes I've ever had. But here's the deal. About 10 years later, I'm in a grocery store and a woman comes up to me and she goes, I know you. You were that trial lawyer. And I said, well, ma'am, I don't recall who you were, so I apologize for that. But can you tell me a little bit about it? She said, you're the reach out and crush somebody lawyer.
You got the message across. She
remembered the theme.
You succeeded.
As it was. Yep.
So, Judge, talking to the young lawyer who wants to be a trial lawyer, because and if they're listening to this podcast and they realize that everyone we've interviewed loves what they do, and so they probably want to follow suit. What do you recommend that young lawyer does? To develop those skills, to get that experience, because my understanding is that trial practice, or at least the prevalence of it, has decreased dramatically over the last few decades.
Yes. So I think one of the best ways to get some trial experience is to be a state court prosecutor because they tried the most cases. I think another thing for young lawyers is to go down to the county courthouse, the federal courthouse, find out what trials are coming up, and go watch some trials. Go watch some trials. For years, I taught appellate advocacy, and so I would tell the students, go down to the Iowa Supreme Court and watch some oral arguments. You will be shocked at how bad they are. And you will learn by watching a few that you could get up and do that. You could get up and do that. I'm going to digress. When I was in elementary school, I would take the public bus down to the public library in the summer. And my dad was a children's dentist, and I'd have lunch with him, go back to the library, then he'd drive me home. Well, after a couple of weeks of that, I got really bored. So I walked down to the county courthouse, which was a couple blocks away, and I walked in, sat in, and watched the burglary trial. And I kept saying to myself, to the lawyer, well, you should be asking this, you should be asking that. And I was in elementary school. I don't know if I was right or wrong, and what I would tell my law clerks, you're going to see a lot of trial lawyers. Most of them are mediocre to bad, but you're going to learn a lot what not to do. And on occasion, you're going to see a really great lawyer. But you can learn as much from mediocre and bad lawyers about what not to do, as long as you can recognize, there's a better way to do it. I'm trying to think the great scientist who invented the telephone. I've got the wrong scientist, but he said there's a great way to do everything. There's a better way to do everything. Go find it. And that was the motto. That's been my entire career. There's a better way to do everything. Go find it. So let me give you a quick example. Almost all lawyers, let's take plaintiffs' lawyers, Sharif, because you're doing a lot of plaintiffs' work now. They think liability and damages, because that's kind of how we're taught to analyze a case. Jurors don't think that way. They don't think in a linear fashion. So I always thought the best way to start a plaintiff's case was to start with a damage witness. Why? Because a really good damage witness, it's very difficult to cross-examine. You cross-examine the mother of a quadriplegic. Oh, you're his mother. Yeah? What kind of cross is that? But the mother can talk about the impact that the accident had. So you establish a couple of things. You start strong because they can't be cross-examined very effectively, and you develop a ton of sympathy. So if you've got a relatively thin liability case, why wouldn't you want the jury to be more sympathetic to your client on damages so that when they get to liability, they're already thinking very positively about your clients? How many lawyers do you know start with damage witnesses? Why?
Yeah, probably not many, right? Because just to what you said, we think of liability, causation, damages, right? And so
that way, they want to know what happened.
Of course. No, absolutely.
Right?
They want the story. They want to do the right thing. And it's interesting. It's oftentimes like I'll go to people when I have I'm preparing for some sort of hearing or some sort of trial. And like, I'll talk to the person who's not a lawyer and I'll say, this is what I intend to do. This is what I intend to say. What do you think? And then their first response is, well, why do you want my opinion? I'm not a lawyer. And then I'm like, well, I mean, actually, your opinion matters a hell of a lot more than mine does, because you're the type of person who's going to be on that jury deciding the case. And so it's interesting how when we step outside of the legal office, the law school, and step inside of a courtroom, it's just very different. It's a very different conversation because we're dealing with very different people.
That is so important, Sharif. I was doing a mediation yesterday. I do a lot of mediations and arbitrations in a false arrest case. The police officer lied on a search warrant, clearly lied. The judge suppressed it. Then they filed a civil suit. And the defense lawyer, very good defense lawyer, very good firm. They appeared in front of me a lot when I was a federal judge. And they were telling me how they workshopped the case among the three top lawyers in the firm, and they had this kind of view of the case. I said, well, I understand that's your view. You defend these cases for a living. That's not how a juror's going to look at it. They're going to be so offended that this police officer lied on a search warrant. Somebody who's supposed to uphold the rule of law not only lies, but lies to a judge. and then searches somebody's house with 23 officers with assault rifles. They search for hours. They find absolutely nothing. You don't think jurors are going to be offended? I looked at the lawyer and I said, I'll bet you $5,000 that they award punitive damages against the police officer. I'm that confident that jurors will be so offended. And they wound up paying about 3 times what they thought they were going to pay to get the case resolved because they saw it through the eyes of defense lawyers. They didn't see it through the eyes of jurors. And I said, this is a relatively conservative venue, but conservative jurors are going to be offended that a police officer lied on a search warrant. Matter of fact, they're probably going to be more offended than the more liberal jurors. And it took them a while to see that, right?
What I've learned is that there is talk that sometimes conservative juries are fantastic because when they,
yes,
I mean, at least from the plaintiff side, because when they're ready to pull the trigger, they got no qualms about it, right? We're talking about a big verdict. They're ready to send that message.
Yes.
Just to touch on your point, Judge, it's so important because often as lawyers, we want to come across as lawyers and we think as lawyers. We need to kind of reel it back and think about the fact that we are human before we are attorneys. And how would a human being would want to get this message across? Don't think about the lawyering part. Think about the human part. And when you start thinking about the human part, then you're going to deliver it as a human to another human and actually connect with them rather than thinking about, hey, I got to prove this element and this element and this element, which is the logical way of going about it. But we're driven by emotion.
Right.
We're driven by emotion. And that's why you start with damages. We're driven by emotion. That's why when I start a jury trial, I start with the mother who lost her son. But tell me about when you first heard about losing your son. How did that make you feel?
Yep.
That's the first witness, and the jury's like, she just lost a son. Guess why? Because everyone, the majority have kids. You got to find ways to relate, and you relate as a human being, not as an attorney, because not everyone thinks like an attorney. And that's, I think, one of the biggest issues that we see.
Yes. You just summarized, I think, the difference between mediocre lawyers and great lawyers.
And Judge, it's you see it, you've seen it your whole career. Sharif and I talk about that. Try to the emotions of the trier of fact, not to their logic or what they expect from a lawyer.
Correct.
Well, you want to break. I mean, what we've talked about a lot now, right? Is what Joe Fried said our last episode is you want to be shockingly vulnerable. You want them to think, wait, I thought I was going to expect this guy with the suit who's going to say A, B, C, D, D. And wow, this guy's now telling me the story. And now he's relating to me in this way. Like, gosh, he's not fitting the mold. He is off code, right?
Right. Absolutely.
It's, and it's interesting. It's not read another book. It's not attend another conference, right? It's almost like, take a step back and just be who you are. And it's easier said than done, and be willing to be vulnerable to a jury in the weaknesses of your case and how you feel about the case, right?
Exactly.
which is why now and I often talk about how the path to becoming a better trial lawyer is often the same path as to developing into a better, more person.
Absolutely. And think outside the box. One of my favorite trial lawyers who appeared in front of me in more than a dozen cases. He tried both civil and criminal cases in federal court. He was trying a criminal case, and it was a very high stakes case. And he actually took, he was something. He was a handful. But he took the chair from counsel table, didn't ask permission, picked up the chair, moved it in front of the witness box, sat down in front of the witness, like 2 feet away from the witness box, and then just had a conversation. Had no notes, and did the direct examination of the defendant in a I felt like I was on the bench peering into somebody's living room, listening to this private conversation. It was gripping, but he changed the dynamic of the courtroom to make it different than questioning from counsel table or from the podium. Now, not many lawyers would have the chutzpah to do that.
Right.
And I love lawyers who think outside the box, so I wasn't going to say anything. The other side, I think, wanted to object, but they couldn't think of what to object to. I would have allowed it anyway. But he totally changed the dynamic, and it made it just a conversation. I've always said that a good direct examination is like a conversation you have with your neighbor, each standing in your yard, talking to each other like humans. That's what a good direct examination looks like, right?
Absolutely.
Judge,
My very first jury trial, I took it over for our senior judge, and I'd been sworn in. It was 2 weeks later, so I was trying a month-long patent case, and I told the lawyers, you can take what I know about patent law, put it in a thimble, and there'd be a lot of room left over. Very first question of the first witness was, does the 7.6 patent read on the 493 patent? And I sent a instant message to my law clerk. What the fuck is he talking about? And this was in a jury trial. Like, I had no idea. I was a federal judge. I mean, I had no idea what he was talking about. Why did he think a juror would remotely understand what that question is? Right?
That's wild. That's wild.
Yeah.
Well, Judge, gosh, I hate to like interject my questions, but
Go ahead.
The comment you made about, or the story you told us about the lawyer who went into the well, took a chair, sat down, and had that direct. There are judges who would not allow that, right?
Yes.
And I think for a lot of practitioners are rightfully concerned that they're going to look like an idiot in front of the jury because they're trying to do something outside the box that the judge is just not willing to have. I frequently see this in voir dire. What are your comments about kind of the role of the trial judge and the, for lack of better words, the leash a judge should or should not give a trial?
Yeah, I think that I recognize probably the majority of judges would have stopped this lawyer. I always wanted to reward innovation and creativity in the practice of law. So unless it was totally out of bounds, was it different? Was it different in the decorum of how I normally have witnesses examined? Yes, but I didn't think there was anything improper about it. So it was fine with me. And you know what? Even if I thought it was improper, oftentimes when a judge comes down on a lawyer, the jurors are kind of sympathetic, like, well, that wasn't that out of line. Why is the judge being such a jerk to the lawyer? So it can actually kind of help you a little bit.
Did you ever at times as a judge think, oh gosh, I want to get more involved in the case, and realize, nope, I've just got to sit here and be quiet, and I'm the umpire calling the balls and strikes?
All the time. All the time.
And how did you come to, I guess, accept that role? Because I recognize, there are some judges who are far more active than others. It can be, there's a wide variety of approaches.
Yeah. You just have to find what you're comfortable with. When you have two really good lawyers or two really bad lawyers, it was easier for me to stay out of it. When there was a big mismatch, I wanted to rescue the bad lawyer and help them. I'll give you an example. I had the greatest Batson challenge I've ever seen in my first year as a federal district court judge in a criminal case. So I called the lawyers up, had a sidebar. We had the noise so the jurors couldn't hear. And so I said to the defense lawyer, I came down kind of hard on him. I said, I'm really shocked you're not making a Batson challenge. And the lawyer says to me, well, I can tell you're really upset with me. So I said, why aren't you making a Batson challenge? And he said, I don't know what one is. So I said, okay, watch me. So I turned to the assistant U.S. attorney. We were at sidebar. What's your legitimate non-discriminatory reason for removing the juror? Blah, 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 blah. I don't believe that. I'm putting the juror back on. And I turned to the defense and I said, that's a Batson challenge. So would I intervene? Yeah. To protect the rights of a criminal defendant? You bet. You bet. I'll give you another example. I had a federal public defender when it came time for closing argument. He said, I'm waiving the closing argument. I said, okay. So I sent the jury out and I said, what do you mean you're waiving your closing argument? And he said, well, I have permission from my client to waive it. I said, I don't care if you got permission from God. You don't have permission from me. You are not waiving your closing argument. I'm going to take a 30-minute recess, and you're going to get up and give a closing argument. And if all you can do is talk about the presumption of innocence and the importance of proof beyond a reasonable doubt, do that. But I'm not, it's an ineffective assistance of counsel motion waiting to happen. So I'm going to give you 30 minutes and you prepare a closing argument. Would most judges have done that? Probably not. But I felt I needed to protect the rights of the defendant in that case.
Judge, what you're protecting is justice and fairness.
Yes.
And that's what you're protecting, is that, your role is to make sure that everyone is treated fairly and justly. And if a party is not doing their job, in a way, the onus is on you to kind of tell them, hey,
yes.
do your job. Do your job, because in the end of the day, you're not judging the attorneys. Who you're judging is that defendant. And that defendant doesn't know better. The practitioner knows better. The defendant does not know better. So therefore, you have to talk to the practitioner who has embarked on this profession, and he's shorting this individual that's now going to may serve the rest of his life in prison.
Yes. I got the greatest piece of advice I've ever received in my life was from the senior judge who I followed. He stayed on the bench until he was in his early 90s, signed an order the day before he passed away. Wonderful guy. Not the brightest guy going, but a heart of gold. And he said, I'm only going to give you one piece of advice, Mark. I said, well, what is it? He said, when you go home at night, you need to look in the mirror and you need to tell yourself, today I did justice. And then he paused and he said, screw the Court of Appeals.
And Judge, I have read that you have had, I believe in sentencing, you've taken some stances that, right, are very contrary to, yes, I guess, what the Court of Appeals has set out.
Yes.
And if I remember correctly, did some of that involve like the crack cocaine disparity?
Yes. Yes.
Would you mind sharing a little bit about that with us?
Yeah, well, so I wrote an opinion, the old crack cocaine disparity was 100-to-1 disparity. So I wrote an opinion saying, I'm not going to follow that. I'm creating my own 20-to-1 disparity. Went to the Eighth Circuit, got reversed. It went in bank, got reversed, then went up to the Supreme Court. They reversed the Eighth Circuit. Said I was well within my discretion to go to the 20-to-1 ratio. The day after the Supreme Court came down with that opinion, I went to a 1-to-1 ratio. And then the U.S. Attorney's Office, who was very aggressive, as they should be, about appealing my sentencing opinions, they totally left me alone. But yeah, I used to set Friday afternoons aside for what I called resentencing days. I often would give the same sentence with a new rationale, and the circuit would reverse me again. I had 2 cases where I got reversed a total of 5 times by the circuit, 3 times in bank. Both times those cases went to the U.S. Supreme Court, and they reversed the Eighth Circuit and adopted my sentencing. So, I was trying to do the right thing, and it was important to me. I had great respect for the Court of Appeals. I recognized that they saw things differently than I did. That's fine. I respect that. But I had an obligation to rule the way I thought was the right way to rule, and I was going to do that. I would oftentimes file an opinion, turn to my judicial sentence and say, well, this one's coming back. Court of Appeals isn't going to like it, but that's fine. They have their job to do. I have my job to do. But I was never going to kowtow to them just because I thought I might get reversed. I wouldn't be able to live with myself if I did that.
You thought outside the box, and then you took that piece of wisdom to heart because you knew you had to look in the mirror.
Yes.
And you knew that you had to do justice and tell yourself, I did justice today. And then you paused and screw the Court of Appeals, right?
Yes. Right.
But not many do that.
Right.
Not many do that because they care about their record, either for reappointment, either for, hey, they just don't want to be wrong. But it doesn't matter if you're wrong.
No.
If you are still fighting for justice and fairness, and that's what you did, and you know why you did it, and we're going to take you back full circle. It's because we talked about how great humans are actually, you see a lot of great attorneys. And it kind of is the same with judges, right? It's doing the right thing. Doing the right thing is simple, and people lose sight of it. We kind of want to complicate simple things to try to justify not doing the right thing, unfortunately. Yeah. So
I was raised to do the right thing. I got a lot of reinforcement. When I was in first grade, my best friend, I didn't know it at the time. I mean, I knew he was not good in school. He wound up in special ed 2 years later. And so my first grade teacher used to pick on him a lot. And one day, instead of picking on him, she picked on another student and she said, if you don't work harder, you're going to be just like Robert Miller. And I stood up out of my chair and I pointed my finger at her and I said, don't you ever say that about my friend. And she came over and she grabbed me by the ear and marched me up to the principal's office by the ear. And the principal chewed me out, called my parents. My father came to school. Principal said I had to write a letter of apology to the teacher. I was crying. We lived three houses away from the school. My dad walked me home, and he said, I could never be more proud of you than I am today because you stood up for a wrong. And he looked at me and he said, in life, you may never get a second chance to stand up for a wrong. So you always have to stand up. And I was sobbing, and I said to my dad, why didn't you defend me to the principal? And he said, because you're never too young to learn to stand on your own.
That's powerful.
Powerful lessons. That guided me throughout my whole career as a judge and as a lawyer and a judge.
Indirectly, we owe it to that teacher to a certain extent.
Yes, absolutely. Yes.
And that's
one of the great things that happened to me.
And
absolutely.
And you know, that's the thing about life is that oftentimes we lose sight of the blessing that's in front of us because we focus on the negative. Here, you didn't focus on the punishment part. You focused on doing the right thing, and the right thing overshadowed anything that came out of that.
So like my high school basketball coach one time said to me, he said, Bennett, you're never going to amount to anything because you don't have any respect for authority.
Yes, Your Honor. That's great. No, but to piggyback on what Niall said, it's amazing. Like we all go through hard times, and
yes,
it's amazing that those hard times in many ways help shape who we are. And oftentimes once we're past those, we're able to look back and say, you know what? It's a blessing. It's because I wouldn't be who I am without those difficult times. And I think the same thing can be said, kind of tying it back to trial practice, right? Like part of being a trial lawyer is going in there and messing up. It's part of it. There's no substitute for getting on your feet and going in there. Now, granted, with the amount of resources out there today, I mean, it would be a fool's errand not to take advantage of it. I mean, your article is a great place to start for trial lawyers. All the different courses. Jerry Spence has 4,000 books. I mean, there's just so much out there that can help kind of guide one's growth as a trial lawyer. But at the end of the day, there's no substitute for getting up there and being okay with stumbling a little bit, being okay with that word stutter.
Absolutely, right? Sharif. And it's an art form. You know, there are lots of rules of civil procedure, rules of evidence, rules of criminal procedure. I get all that. But the bottom line is most part of trial work is the gray area. And so my philosophy always was as a lawyer was, unless the judge has stopped me, I haven't gone far enough. And if the judge stops me, I have to be very graceful in apologizing and backing off. But you can get away with a lot of stuff before a judge is going to stop you. And you can't be fearful of pushing the boundaries because we don't know where those boundaries end. And they're different for every judge you practice in front of. The boundaries can be very different.
It could be different depending on the day. I mean, in all fairness.
Yeah. And so being a zealous, I mean, you can't do anything unethical. I get that. But I'm not talking about anything unethical. I'm talking about when you represent a client, I don't care who your client is, you have an obligation to be a zealous advocate for that client. And you can't be afraid if a judge is going to think, well, gee, maybe you shouldn't have done that. Well, maybe I shouldn't have done it. But I didn't know until you told me I shouldn't have done it. I mean, some things you know you can't do. But a lot of things, it's just a gray area. And your obligation is to push that. And you have to have a strong enough sense of self that if a judge stops you, it's not the end of the world. The sun is going to set that night. It's going to rise the next morning. And you're going to learn from the mistakes you do. And they're not necessarily mistakes just because a judge stops you, but it's a good lesson. How far can I go with this judge?
And both Sharif and I, we push the envelope. I push the envelope often because I'm in front of different judges. So if I'm in courtroom 1, it's different than being in courtroom 2, and it's being different being in courtroom 5. So for me, I do push the envelope, and when the judge has Mr. Abuzaki move on, I'm like, yes, sir, Your Honor, and then we move on. It's not as difficult as people make it seem in their mind. It's a lot more complicated up here than it is in reality. You know, I've done it on direct examinations, cross examinations. There's a case when I've shared with Sharif where I had an eyewitness die about a month before trial. And when you have an eyewitness to a murder, investigators kind of say, hey, it's a slam dunk case, so we're not going to do our job because we have an eyewitness to them. She was on scene. So I put my detective up on the stand, and I was like, Detective Rosser, how long have you been a police officer? He was like, 24 years. I was like, how long have you been a detective? He was like, 19 years. I'm like, how long have you been a homicide detective? He was like, 16 years. I was like, so now taking your 16 years as a homicide detective, your 19 years as a detective, your 24 years as a law enforcement officer, did you take that with you to the crime scene? Yes, I did. Did you speak to anyone at the crime scene? Yes, I did. Who did you speak to? I spoke to a Miss Hunter. How long did it take you to develop a suspect after speaking to Miss Hunter? As soon as we finished our conversation. So I was like, was that within 5 seconds? Within 5 seconds. Who is the suspect that you developed after speaking to Miss Hunter? He said the defendant's name. I was like, can you point him out for the jury? And defense counsel didn't know what to do. He's like, what can I object to? There's nothing to object to. Well, how do you object? I'm not getting any hearsay statements in.
Right. You're not getting into what the witness said, just how great, brilliant.
And Judge, right after that, I introduced her death certificate. It's self-authenticating. I introduced it. Then now the jury knows why Miss Hunter is not present. So it's those things that even the judge was looking at me, and the judge was like, where's Mr. Abuzaki going? And I knew he wanted to find something to be like, stop, because he knew Miss Hunter had died because we had some pre-trial motions. But there wasn't anything there. So it's those things that, and I know Sharif has done it in voir dire, and he does it often in voir dire. So that's one of those things that I say, if you're a trial attorney, push the envelope.
Absolutely.
With grace and respect and humility.
That's
the important part, with grace and humility, yes.
And that's what makes it fun. It really does. It's a great profession. Now, Judge,
it's an art. It is
now
not science.
But based on, I've followed you for years now, Judge, and you've written a lot about kind of this art dying or declining. Can you talk a bit about that?
Well, I think every time, like we'll talk about civil cases, every time the Rules Committee in federal court adopts a new rule, which they think is going to make litigation less expensive, it has the opposite effect. It makes it more expensive. And so litigation has just gotten so expensive. If they actually wrote a law review article that we ought to switch the civil and criminal rules. In federal court and criminal, you don't get to take depositions. There's very little discovery. The government turns over what they have. You don't get to depose any of the witnesses. Heck, you don't even get to know who they're going to call as witnesses. But in a civil case, you discover everything to death. We ought to switch it. I think justice was actually better prior to the passage of the Federal Rules of Civil Procedure, where it was more the Wild West. It rewarded creativity of lawyers. You know, now we have cadres of litigators that have replaced trial lawyers. They can take a 7-hour deposition of every witness imaginable, 99% of which they're never going to use in trial. But they can't cross-examine a witness in trial. And so I think we've overruled things. I mean, too many rules, and we've made it too complicated and made it too expensive so that everybody settles now. Everybody settles cases now. You know, when I first started as a district court judge in like 94, I think I tried 17 civil cases my first year. My last year, I think I tried 4. And I know federal judges from around the country who had gone years and not tried a civil case. It's tragic. It's tragic because I believe the Seventh Amendment. I'm a huge believer in the right to trial by jurors. Jurors are amazing. Almost always, do they always get it right? Of course not. Judges don't, but they usually get it right, way more often than not. And there's something about the collective wisdom of a group of jurors that exceeds the wisdom of all the lawyers and judge in the courtroom, in my judgment. And I believe that to my core.
The humility, Judge, and that's what's important about that is, you know, we always think we're smarter. And often when the jurors don't get it right, it's because one side or another just didn't do their job to the extent that they could.
Yes.
For me, I can't look back at a single case and say, you know what, I disagree with the verdict that the jury came back with. Not one that I've had. I'm sure others will say, oh, no. For me, it's because, you know, if you do your job, you're going to get that message across. And when you get the message across, sometimes we lose sight of the fact that who we're trying cases to are human beings. Human beings, a being that we are from. So they're very similar to us. And I often say, and I throw out this statistic, that 99.9% of all human beings are genetically identical. So they kind of,
right.
They think like you, they talk like you, they have the same emotions as you. So find ways to connect to those emotions.
Yes.
And when you fail to connect, then they're not going to come to the right verdict.
I treated jurors as royalty in the courtroom. Matter of fact, you guys will get a kick out of this. In the courthouse that I used primarily, they would have to come up from the floor below where the jury assembly room is, and then they walk through the back door of the courtroom. So I would stand there without my robe on. I would stand there and shake hands with all the prospective jurors and just say, welcome, I hope you have a good experience. Thanks for coming. I had about 20 different lines I would say, and I would shake hands with each one. They thought I was the frickin' Walmart greeter at night and the courtroom greeter. And then when the last juror went in the back, while they were still getting situated and seated, I ran down the hallway, put on my robe, walked out into the courtroom, and you could see them smile and chuckle. But I made a connection with them. And then I would constantly remind them they are the most important people in the courtroom. They are the most important people in the courtroom. And they were. And I had so many jurors after the fact write me and say, when can we come back and be a juror?
I bet you they weren't thinking that before they
not at all.
Walked into that courtroom.
No. And I would say, you all are going to try and get out of jury service. I know that. I've heard every excuse imaginable, but you're going to come up with some I've never heard. And it's going to be very hard because I think jury service is important. I remember I had an orthodontist in town. Didn't want to serve on the jury, so he wrote me a letter, too important, blah, blah, blah. I said, no, you're serving. Hired a lawyer, he wrote me a letter. I said, no, you're serving. And he wrote me another letter saying, well, if I have to serve on jury duty, I'm not going to be able to pay my hygienists, and they're going to lose out on salary. I wrote him back and I said, if you're too cheap to pay your employees when you're serving on jury duty, that's your problem. It's not my problem. And I made him serve. I had another this is a great story. I had a postal worker who didn't show up 4 different times for jury service. So I had the U.S. Marshals arrest him and bring him in on New Year's Eve day. And I asked him, and he brought his wife, and I said, why didn't you show up? Well, I'm a postal worker. I'm too important to serve on a jury. I said, I'm not sure I heard you correctly. Would you repeat? And he told me what he said. I said, well, do you have plans for New Year's Eve tonight? He said, oh, yeah. We've gone out with the same couple for 20 years, and we're going out for dinner with them. I said, well, I'm not so sure, because you're going to be in the Woodbury County Jail tonight serving 1 day in jail. And I don't think they allow guests, even on New Year's Eve, to come dine with you. So you're going to have to postpone that dinner. It made the local newspaper, and it cut down the number of people that didn't show up for jury duty dramatically.
Oh, I bet.
Nobody's too important to serve on a jury. I was called as a judge. And I showed up in state court. Of course, I wasn't going to get picked, but of course I had an obligation to go. It's important. It's important. And I would see lawyers. I had a series of about 100 cases that dealt with farm grain delivery. They were called hedge to arrive cases. Most of them settled, but I probably tried 10 jury trials. So I'm in a jury trial. We're in jury selection, and a lawyer is talking to a prospective juror, and he says to her, well, this is a hedge to arrive case. Do you know what that is? And she said, no. And he starts acting all indignant that she didn't know what a hedge to arrive case was. And I thought to myself, you not only just made an enemy of her, but everybody on the jury. I've tried a dozen of these cases. I don't even know what a hedge to arrive case is. This was my self-talk. Why would you ever denigrate a juror for not knowing something, a prospective juror? Unbelievable, right?
I agree with you wholeheartedly, Judge. And it's even starting before getting to the jury. I try to create the tribe that Sharif talks about often. The second I stand up, I tell them the only reason why I'm standing up is because this community has been victimized. That's the only reason I say, because I represent each and every one of you. You know, and I start so they know that, hey, it's there, and it doesn't matter who I am, doesn't matter what my name is. It's what's my job.
Right.
What's my job as a minister of justice? And let me tell you what it is, right? So it's making sure that you build that credibility, and you tell them and you give them the power that ultimately, in the end of this case, you are the one that's going to make this decision. And it's that making them feel like royalty. It's elevating them. It's giving them the power from the start to start thinking about, we are the decision makers here.
And it's the truth, right? I mean, we're in a courtroom because there is a problem, there is an issue that needs to be resolved, and the people who need to resolve it and fix it are the judge.
Yes.
I mean, that's
I tried I think it was a 4-week trial involving a right-wing group called We the People, who didn't believe that they had to pay taxes. And we had, they filed every motion imaginable. I didn't have jurisdiction because the flag had fringe on it or didn't have fringe on it. I don't remember. I was very patient with them. They never stood when I came into the courtroom. So the day before, we're on a Monday going through final stuff, starting the trial on Tuesday morning. None of them stood up. And I said, well, here's the deal. I've noticed for the last 6 months, you've never stood up when I came into the courtroom. It's tradition that you do that. And here's the thing. It didn't bother me. I know you don't believe I have any authority, but I am the trial judge in this case, and we're going to have a jury trial starting tomorrow. So here's a little piece of advice. When those jurors come in tomorrow morning, don't stand for me. Don't stand for them. Stand because you don't want them upset with you for not standing. It's a matter of respect. And I figured they're not going to stand. Sure enough, they all stood up.
Well, self-preservation, right?
Yeah, right. It's a big motivator.
Well, Judge, I mean, this has been great. I'd like to end on a high note, but I'm about to ask maybe somewhat of a depressing question. Is there hope for the trial bar, right? I mean, you mentioned that there's the trial lawyer in some respects has been largely replaced by the litigator. What are your thoughts next 5, 10, 15, 20 years about trial practice in the U.S.?
I'm optimistic by nature. I'm not optimistic that we're going to increase the number of trials or that we're going to have a lot of opportunities for young trial lawyers to get involved in the trial practice. I think unless we can make the rules less complicated and substantially reduce cost and delay, the problem is that with litigators is they spend so much time and money on a case that their clients can't afford to go to trial on the civil side. We ought to make it much simpler, substantially limit the number of depositions, the length of depositions. I never took a deposition more than 2 hours, ever. And normally I didn't depose the other side's witnesses. I thought it was a big advantage not to depose them. They had no idea where I was coming from. But I took a kind of minimalistic approach. I mean, I was super prepared, but I didn't have to. I wanted to know what exhibits they were going to use against me, who the witnesses were, and what they would likely testify to, but I didn't need to take their deposition. I figured out the worst, and it was seldom as bad as what I thought it could be. So I think discovery has gotten way out of hand, way too expensive. There's got to be a happy medium between the old trial by ambush and the way this extensive discovery that is so expensive that litigants can't afford to go to trial anymore. There's got to be a happy ground, but it's going to require major changes in the rules of civil procedure. I've written an article about it. I said, look who's on the federal rules of civil procedure. They don't have lawyers from Marshalltown, Iowa, or Fargo, North Dakota, or here, South Dakota. They have big firm lawyers from big cities who are litigators, and they make the rules to fashion their style of practice. And that's just all that does is discourage jury trials. Just discourages the heck out of jury trials. So we have to reduce cost and delay. And I think if we did that and took away the incentive that litigators have to litigate rather than try cases, then trial lawyers would be at a premium, and litigants would be dying to hire real trial lawyers, not litigators. Is that going to happen? Doubtful.
If we're going to end on a note of how to become this great trial lawyer that you've written so much literature on, in 30 seconds, what is it?
You have to have the desire and passion to be the best that you can be, and that takes an incredible amount of hard work. You have to find role models. It's good to read about it, but you have to watch and you have to second chair really good trial lawyers. And then you have to be fearless. You have to be fearless because not every trial is going to go like you thought it was going to go. Things are going to go south, and you have to pick yourself up and learn from that and not be discouraged by it. The word is gritty. You have to be gritty. I mean, Jerry Spence is a great example. He flunked the Colorado bar. The Colorado bar once, I think maybe twice. He lost his first 8 civil jury trials and then became the top trial lawyer in the country because he was gritty. He didn't give up. If you give up easily, you need to find another profession. Go be a dentist. Do something else. But you can't be a trial lawyer if you're going to give up. Everybody's going to be discouraged, but you have to learn from the mistakes that you make and try and do better. One of the cases I'm most proud of is I had read about these series of cases. It happened to be a race discrimination case involving a disease called pseudofolliculitis barbae. There were 7 reported cases, including 2 at the Court of Appeals level. Every plaintiff lost. But it was a really intriguing theory to me. And within a 2-week period, I had 2 guys walk into my office. They each got fired because the company wouldn't let him grow a beard a quarter inch in length, which is the only remedy for pseudofolliculitis barbae, which is hairs that turn inward. And I thought, this is a winning case, but everybody's lost. So I called all of the lawyers and talked to them. I even went out to see one, went through his file. And I spent an enormous amount of time figuring out why they lost. And I decided I could win these two cases because I would learn from the mistakes of others. And I did. I was able to figure out what they did wrong. I hired a much better expert, and I won both cases, including going against the former chair of the EEOC, who was in private practice, William Brown III, from Snyder, Lewis, Harris, in Philadelphia. He was a hard-nosed lawyer. He fought me on everything. But after I won, he was incredibly gracious, and we became good friends. But I suckered him into thinking I was a small-town country bumpkin. And every time I talked to him, I'd say, Mr. Brown, I just don't know what I'm doing in this Title VII stuff. You're the expert. Please go easy on me. I don't really know what I'm doing. And he bought a hook, line, and sinker. And when it came for trial, because I did very little discovery, I was so well prepared, I just smacked him around the courtroom. It was hilarious. I outworked him. Even though I was at a big firm, he had tried these cases. He had won them all. I figured out what his weaknesses were, didn't let him know I knew what those weaknesses were. And bingo, it's just hard work. So I think you can rise to the top of any profession if you're willing to work hard enough to do it. Skill alone will not get you to the top.
Willing to die on a treadmill.
Right.
Judge, just briefly, I want to thank you for every right you've done, not only as an attorney, but as a judge from the bench, every time that you saw wrong and didn't allow it. So I want to thank you for that, and I appreciate you so greatly.
Well, thank you, guys. I love what you're doing. I'm going to be a big fan. I'm going to listen to your podcasts. I really applaud what you're doing.
Thank you,
Judge. I appreciate it.
You're a superhero.
I was gonna start a podcast. I didn't really know how to do it, so I never got around to it. So I admire you guys for doing it.
We'll help. Give us a call. We'll help. Happy to do it. No, happy to help.
And we're preserving a voice of the great, and you're one of those greats. So that was one of the main reasons we created that podcast, and we're still enjoying it, is because we're preserving voices like yours.
Yes, thank you guys so much. I'll tell you, it's been an incredible honor and privilege to be on your podcast.
Well, Judge, we look forward to staying in touch with you.
Yeah.
And again, we're truly grateful to have you on here. Thank you for everything.
Thank you for listening to this episode of RVA Trial Lawyers, Virginia's trial lawyer podcast. For more episodes, check out rvatriallawyers.com.